Okay, right, this is the lecture that we missed yesterday because the system came down. And so I'm just going to record this now and post it today. So I think last time we had gotten to this slide. So this is dealing with a person who is downstream of the holder in due course. So the holder in due course is that definition in section 29 of the Bills of Exchange Act. If you can satisfy that definition, then you obtain a better title to the negotiable instrument than the person from whom you obtained the instrument. So that is the concept of negotiability, the ability to negotiate something within the meaning of the negotiable instruments concept is the ability to give a better title than you yourself have, even though it's not intentional. If the person to whom you negotiate the instrument is a holder in due course, they have a better title than you have. And then the issue is, well, what about people downstream of the holder in due course? Well, that's section 29.3, and I went through that last time. So, all right, now crossings. A cheque, which is a bill of exchange drawn on a bank payable on demand, may be crossed two parallel lines. They might go vertically up, down, or they might go on the angle. Either is possible, and contain the words not negotiable. Section 76 of the Bills of Exchange Act. Not negotiable does not preclude the transference of the cheque. The word negotiable does not mean, it's commonly used to mean transferable, but it doesn't mean that technically. It means that an exception to nemo dat applies. You can give a better title than you yourself have. So what does not negotiable means? Well, it means the opposite of that. It means that you're not capable of giving a better title than you yourself have. So the holder in due course who takes a cheque crossed not negotiable will obtain the same title as the person from whom they got the cheque. In other words, we're back to the general rule of nemo dat. And not only will you not get a better title than the person from whom you obtain the cheque, but you will not be able to give a better title than you yourself have. Okay, so it's back to the general rule of nemo dat, non quod habet. No one can give what he does not have. Okay, so back to the general law. Here's an example. A draws a cheque on his bank. Let's assume it's an American cheque because that's all we're dealing with now in New Zealand. A draws a cheque on his bank WSB payable to B, his employer or bearer, crossed and containing the words not negotiable. C steals the cheque from B and immediately offers to sell it to Western Union. Western Union rings the bank, inquires whether there's any countermand on the cheque, and is informed there is not. It purchased the cheque at a discount on the named amount. A countermands the mandate and WSB does not pay when the cheque is presented. The issue is Western Union entitled to payment? Answer no, because it's a not negotiable cheque, so the thief is only able to give as good a title as the thief has. That title is vulnerable to the position of the true owner, B, and because it's marked not negotiable, Western Union is in the same position as the thief. It obtains the thief's title from C, and therefore it's not entitled to payment. So that's B is the answer there. That's the effect of crossing a cheque and marking it not negotiable. You're back to the position of nemo dat, You can only give as good a title as you yourself have. Under the Checks Act, I'm going to pass over this actually because this is limited to domestic law. I don't think, I'm certain that there is American law providing that checks are not transferable. So if I'm sure that American checks can be marked not transferable, non-transferable, account payee only. The check is only valid between the immediate parties to it and is simply not transferable. That's our domestic law. I'm obviously not asserting that that law applies to American checks, but I'm certain that American checks can be made non-transferable. That's actually quite an important point from the perspective of the New Zealand banks collecting on American checks, because of course if they let the funds clear, if the New Zealand bank lets the funds clear before the American bank pays on the check, the New Zealand bank would be collecting in its own right, but yet the check is not transferable. That's of course if it's marked not transferable, not non-transferable. So that would suggest very strongly that the New Zealand bank ought not to let the funds clear and purport to claim as owner of the check. So it should only operate as a collecting bank. It should not operate as a claimant in its own right by essentially purchasing such a check, because by definition it's not transferable. And so if a check which has been made non-transferable carries endorsement intended to negotiate or transfer ownership, that will be legally void. Now, of course, there may be a claim by the transferee against the transferor. There may be a personal claim against them in the nature of a warranty, but that's a different issue. But as a matter of law, ownership of the check is not able to be transferred, and so the transferee would have no claim against the drawer. Now, what about the rules for presentment? For acceptance, remember that the undertaking under Section 55 is that on due presentment it shall be accepted and it shall be paid, and there's this distinction between acceptance and payment. Acceptance is where the bank actually accepts the drawee. If it's not a check, it might, remembering that bills of exchange include checks. Not all bills of exchange are checks, but all checks are bills of exchange. But let's assume it is a bank. So there's a distinction between presentment for acceptance and presentment for payment. And Section 39 sets out the circumstances in which there's that you have to present for acceptance distinctly than for payment. Remembering with checks, they're payable on demand, so acceptance and payment occur at the same time. You just make demand on the bank, stamps it, accepts it, and then pays. By contrast, bills of exchange, more generally, there's in certain circumstances you've got to present for acceptance distinctly than for payment. That's if it's payable after sight. That means that the occasion for payment is different than the occasion for acceptance. So if it's payable after sight, meaning it's payable after when you present it for acceptance, so then there's obviously two different occasions. Where the bill expressly stipulates that it shall be presented for acceptance, So the terms and conditions of the bill, the tenor, to use that expression that the Act itself uses, expressly stipulates that it shall be presented for acceptance, or where the bill is drawn payable elsewhere than at the residence or place of business of the drawee. In other words, there's a physical distinction between the location for acceptance on the one hand versus payment on the other. And that can be so where, for example, the drawee has a treasury located in one place, but it administers instruments somewhere else. This is quite possible. So in that circumstance too, the bill has to be presented for acceptance before presenting for payment. Presentment for acceptance is distinct from and precedes presentment for payment, section 39.2. Yeah. Promissory notes need not be presented for acceptance, section 90, subsection 3. What you'll see when we look at the rules on promissory notes is that what happens is that the Act generally applies the rules on bills of exchange to promissory notes, and as I've already mentioned, although bills of exchange are much less significant in practice now than they used to be, there is a residual relevance, mainly foreign checks, but there's quite a bit of law on promissory notes which they're still being used, letters of credit, performance bonds, etc. Medium-term notes, short-term notes. So you need to learn the rules on the bills of exchange to know the rules that apply to those promissory notes. So that's why I'm going through this in a bit of detail. Anyway, promissory notes need not be presented for acceptance. You simply make demand for payment consistently with the tenor of the note. Bills of exchange and promissory notes must be duly presented for payment. Duly relates to the occasion for payment. So you've got to present them duly. If it's not duly presented for payment, the drawer, the person making the bill or the note, and any endorser is discharged to the extent that they are prejudiced by the omission. To the extent that they are prejudiced by the omission. So what there is a mitigation of a liability on the promissory note or the bill of exchange. So your liability in debt for a note or damages for a bill of exchange is reduced to the extent that there's a prejudice by the failure to duly present the instrument for payment. Now, I'll come back to the issue of what kind of prejudice there might be, because this, on the face of it, is a slightly odd concept, but I'll come back to that. When are they duly presented? So section 45 tells you when they're duly presented. Presentation for payment on the day it falls due, if it's not payable on demand, because if it's payable on demand, you make demand. And then if it is payable on demand, presentation within a reasonable time of its issue, and presentment within a reasonable time of its endorsement for the endorser to be liable. Okay, so that's your second bullet point there. What's a reasonable time? Well, in each of these situations, the nature of the instrument, trade usage, and the facts of the particular case must be taken into consideration. It's what we might call a matter of practical deliberation. And customarily in New Zealand, that has thought to be about 6 months. About 6 months. And to be honest, I don't know what the position is on American checks, which is the crucial is the crucial factor now, because the domestic checks are no longer being used. I would not be surprised if it's the same. Checks should be presented for payment within a reasonable time of its date of issue. By definition, they're payable on demand. So you're talking about the same rule as applies to bills of exchange and promissory notes payable on demand. And a reasonable time for presentation should be determined with regard to the nature of the instrument, trade and banking usage, and the facts of the particular case. Section 74B of the Bills of Exchange Act. Now, so if a cheque is not presented for payment within a reasonable time of its issue, and the banker is otherwise obliged to pay on the drawer's cheques, the drawer will be discharged to the extent that she has been prejudiced by the delay. That's the same as applies to bills of exchange generally. Discharged to the extent that they are prejudiced by the omission. Okay, so the same mitigation of liability. Now, what kind of prejudice would you suffer by delay? That's a really good question, and I actually did some research on this, and the answer is that the foregone interest on money deposited into a current account to provide the funds to ensure that the drawery bank honours the cheque / bill of exchange is the prejudice. That's what the case law says. So it's the foregone interest. You have to have the funds in the account to ensure that the cheque is honoured, and if the payee or bearer, for example, doesn't present it within a reasonable time, you're out of pocket to the extent of the opportunity cost, and that can be applied to mitigate the damages liability on the bill of exchange, cheque, or promissory note. Now, interestingly, Section 74C of the Bills of Exchange Act says, if the drawer is discharged, the holder of the cheque will become a creditor of the bank in lieu of the drawer. The holder will then be entitled to recover the amount of the debt from the bank. I find this virtually incomprehensible. Why, if the drawer is discharged entirely by reason of the fact that the payee doesn't present their cheque for payment within a reasonable time, why does that convert the payee into a creditor of the bank? I'm sorry, just to understand the rule, the reason for it, I don't know. I have looked into this, tried to find an explanation for this rule in the commentaries. I haven't located one. So, just understand the rule, and the reason for it is obscure. I'm sorry, I've done my best. Bearing all those propositions in mind, X issues a cheque to TECO Limited drawn on A's bank WSB in the amount of $1,000. TECO's accounts clerk mislays the cheque and discovers it in a drawer 6 months later. TECO presents it for payment at the bank. The bank refuses to pay the cheque. TECO sues A on the cheque. A is liable in the amount of the cheque, or A is not liable in the amount of the cheque. Yes, the payee has to present the cheque within a reasonable time, and 6 months has passed, and by custom This is not presentment within a reasonable time. Okay, so in principle, the mitigation of liability, not the elimination or exclusion of liability, but the elimination of liability, the mitigation of liability is possible, but you would need to show it. You would need to evidence the prejudice, for example, the opportunity of cost of having funds lying in an account when you could usefully use them. So yes, there's an economic cost there, and there may indeed be a pecuniary cost. But either way, neither is actually suggested on the facts. And so if there's no evidence of actual prejudice, then the drawer is liable on the cheque pursuant to Section 55 of the Bills of Exchange Act. Okay, now, so that means that A is the right answer. A is liable on the amount of the cheque. If there were prejudice by the failure to present within a reasonable time, then B would be the right answer. A is not liable in the amount of the cheque, although A would be liable in the amount that represents the difference between the amount of the cheque and the prejudice suffered. You would deduct that to mitigate the liability. So there's a reduction in liability, not an exclusion of liability. Right, promissory notes, what are they? There's a very small number of sections in the back of the Bills of Exchange Act which deal with promissory notes, and promissory notes are still a live issue in New Zealand domestically, as I've already mentioned. So what is a promissory note? It's an unconditional promise in writing made by one person to another person. So we're talking here about a two-party transaction in contrast to a bill of exchange which involves three parties: the drawer, the person making the bill, secondly the drawee, which is normally a bank but not limited to banks, and the payee. So you've got three parties there. Promissory notes, two parties, so a less complex legal relationship, because remember the three parties involve at the level of drawer, drawee a mandate, as between drawer and payee a contract. Okay, so there's two legal relationships going on there. By contrast, promissory note, one legal relationship between two people, just a promise to pay a sum of money. It's a kind of a formal contract. Anyway, an unconditional promise in writing made by one person to another person, signed by the maker, engaging to pay on demand or at a fixed or determinable future time a sum certain in money. That expression, sum certain, think back to that fundamental definition of a debt early in the course, defined by Chief Justice de Glanville in about 1185, so it's very old. Same expression here, sum certain in money. Notice, in money, made out to a specified person, specified person's order or to bearer. So again, you get this distinction between the ways in which ownership of the note can be transferred. If it's an order note, then you have to endorse it to transfer it. If it's a bearer note, you just deliver possession of the note. And banknotes, they are now by statute legal tender. They are equivalent to money in almost all respects, equivalent to coins, I should say, apart from that residual aspect of you can go and demand a note to be converted into coins. They have that residual promissory note characteristic, but in all other respects they're equivalent to coins for the purposes of paying debts. So banknotes are promissory notes issued by banks. That's the origin of the banknote. So we're talking here about the legal concept that is the origin of the banknote. The promise to pay must appear on the front of the note, distinguishing a promissory note from a mere acknowledgement of debt. The difference between an acknowledgement of debt and a promissory note goes beyond the promise to pay. An acknowledgement of debt is a documentary evidencing of a pre-existing debt. By contrast, the promissory note, the note itself comprises the debt, a debt incorporated into the instrument itself. So there's a subtle distinction between a promissory note and an acknowledgement of debt, in addition to this distinction here that the promise to pay must appear on the front of the note. For a promissory note, in contrast with acknowledgements of debt, they don't have to be on the front of the document. And the instrument must consist substantially of a promise to pay a sum of money and nothing else. An example, A signs a document recording his promise to pay the sum of $10,000 to C&N Car Sales Limited for the purchase of a car, title ownership of the car being retained by C&N Car Sales Limited until payment of the purchase price. The issue is this a promissory note? Answer, no, it's not a promissory note. Oh, something's dropped off there. I'm sorry, I'll fix that. This instrument is not a promissory note. It's actually chattel paper under the Personal Property Securities Act, which I'll go through later in the course. But notice here, not only is there a promise to pay, there is also a retention of property or title to the car to secure payment of the purchase price. So if the purchase price is not paid, the title or ownership or property in the car gives C&N Car Sales Limited the right to possession of the car. They can repossess it from the purchaser. So this is a what's called a retention of title clause. It's a security interest under and for the purposes of the Personal Property Securities Act. So yeah, it's not a promissory note because it's doing more than promising to pay. If that retention of title were not there, it probably would be a promissory note. So the statutory provisions relating to bills of exchange also apply to promissory notes, subject to certain exceptions and modifications. That's what Section 90, subsection 1 of the Bills of Exchange Act provides. And then in applying those provisions relating to bills of exchange to promissory notes, the maker of the note is deemed to correspond to the acceptor of a bill, while the first endorser of a note corresponds to the drawer of an accepted bill payable to the drawer's order. Why is it doing this? Well, it's if you think back to bills of exchange, if the drawee, which in the case of cheques is a bank, accepts the cheque, then there is a direct obligation from the acceptor to the payee, and if the acceptor doesn't pay, then the payee can sue the acceptor directly. They can also sue the drawer, but they have two people to hold liable, including relevantly the bank. So an acceptor accepts an obligation to pay the payee directly. That's a debtor-creditor relationship. You can see why in applying those provisions, the maker of a promissory note is deemed. The word deemed just means a conclusive judgment of the law. My name, Dempster, is actually derived from this verb to deem. The judges in ancient Scotland were called Dempsters and then Dempsters, and in fact on the Isle of Man, the judges on the Isle of Man are called the Dempsters. So my ancestors were judges, so my interest in law is genetic apparently. Anyway, the maker of a note is deemed, it's a conclusive judgment of the law, to correspond to the acceptor of a bill. The liability is identical. It's a promise to pay directly. By contrast, the drawer of a bill of exchange doesn't promise to pay. They promise the payee that the drawee will pay. That they promise that somebody else will pay. Okay, that's a different type of promise. That's why the liability is not in debt, it's in damages. And then the Act, Section 90, subsection 3 goes on to say that the following provisions do not apply to promissory notes. Presentment for acceptance and acceptance. Now that might cause you to scratch your head at first look. You've just been told the maker of a note is deemed to correspond to the acceptor of the bill, or acceptor of a bill, but then presentment for acceptance and acceptance don't apply. Why? What's going on here? Well, if you look at Section 90, subsection 2, the maker of a note is deemed to correspond to the acceptor of the bill. That word deemed, again, is key. That means that the procedure by which acceptance occurs, namely presenting the cheque or the bill of exchange for acceptance and acceptance by the drawee, are just not relevant. Okay, because they're not relevant, they don't apply. The maker of a note is deemed to correspond to the acceptor of a bill as though the bill were already accepted. That being the case, then the process for acceptance, namely presentment and acceptance itself, you don't need to apply those. You just have to assume, for the sake of interpreting those provisions, that the maker of the note is already an acceptor of the bill, and there's a direct liability by the maker of the note in favour of the payee or bearer or to order. Now, it's a slightly inelegant way of setting out the liability of the maker of a promissory note. They could have done it in a more direct manner, but they didn't, and I have to explain it to you. And this is relevant because, as I've said repeatedly, there are promissory notes in New Zealand in domestic banking now. Okay, so in contrast to cheques, promissory notes are a live issue. And actually we'll get to one of those examples soon. All right, the final slide is, in addition to being negotiable instruments, bills and cheques and promissory notes are also regarded as both chattels, tangible, personal movable property, the document itself, which incorporates the legal relations, so it's a chattel, and they are also shows as an action. And as chattels, bills, cheques and notes can be bought, sold or deposited to secure payment of book debts. As shows as an action, they can be assigned or charged. What this means is that you can get different legal regimes applying to negotiable instruments than the Bills of Exchange Act. Okay, and actually I'm not certain yet what the content of one of the tutorials will be, and whether it would be more practical for you to do something other than negotiable instruments. That might be true. I haven't yet decided, but the one that I have done in the past, when domestic cheques was still a big issue, was a classic example of this. But as I say, I'm not yet certain on this point. But the key point is that you've got a regime in the Bills of Exchange Act which applies to promissory notes and residually to cheques. And so, the legislation applies in accordance with its terms, but you can treat the liability on a promissory note, or indeed the liability of an acceptor in favour of a payee on a cheque or bill of exchange, and arguably even the liability of a drawer to the payee pursuant to Section 55 of the Act as a shows in action in the nature of a debt. And so you can apply the law of choses and actions to these liabilities, as well as the law of the Bills of Exchange Act. You can also apply the law of goods and chattels and the law of torts to these instruments as well. So it can get quite complicated. But the key point is that in those cases, the person taking the bill or the cheque acquires the same title as that of the person from whom it is taken. In other words, you're back into the realm of nemo dat, because you're not treating these as negotiable instruments. You're treating them as a chattel or a shows in action. Okay, so that means that the law is quite complicated, and you have to think carefully about whether or not we're in the regime of the Bills of Exchange Act on the one hand, or the regime relating to shows as an action and the assignment of shows as an action in the Property Law Act, and the law of sale of goods, etc., or transfers of ownership or possession of goods. So, yeah. All right. Right. So turning now to guarantees, performance bonds, debit and credit cards. These are all big in banking, very practical. Starting with the guarantee. What is a guarantee? It's an engagement, that archaic English word meaning a contractual covenant by the guarantor. Sometimes the guarantor is called a surety, because he or she assures that somebody else will perform their contract or their obligation. So it's an engagement, a contract by the guarantor or the surety to assume liability for the duty owed by another person, who we call the principal debtor, if the principal debtor defaults on her duty. It's distinct from an indemnity, which is a promise independent of the scope and enforceability of a duty owed by the principal debtor. So an indemnity is a promise to hold somebody harmless against loss caused, and that loss caused might be loss caused otherwise than by a breach of duty owed by a principal debtor. Okay, and can include a breach of duty by a principal debtor, but it's not limited to. By contrast, a guarantee is always dependent on a duty owed by the principal debtor. So there's a perfect concurrence, if you like, or an overlap between the duty of the guarantor and the duty of the principal debtor. So just testing that, A co-limited contracts with B co-limited to compensate B co-limited if B co-limited is found liable to C co-limited for negligent performance of its contract. this is a very fine line. The choice you have is A is a guarantor of B, or A is an indemnifier of B. The answer is B. This is a contract of professional indemnity. So the insurance company insures against against professional negligence. It's not an insurance against performance of the contract. It's an insurance against negligence in the performance of a contract of professional services. That's the content of the obligation of indemnity undertaken by an insurance company on a contract of professional liability for negligence. So B is the right answer there. What is the content of the contract undertaken by the guarantor or the surety? So it is that if the principal debtor defaults on his or her duty or its duty, the guarantor can either perform the debtor's covenant personally or pay damages in lieu of performance. Okay, so the guarantor has a choice either to step in and perform the acts that are the subject of the principal debtor's contract, or failing to do that, pay damages in lieu of performance. So it's pretty unusual actually for the guarantor to perform personally, to step in and do what the principal debtor was required to do under their contract, but it does happen. And of course it happens all the time if the principal debtor's obligation is to pay a sum of money. In that circumstance, then yes, the guarantor always steps in and performs by paying money. But if it's an obligation other than to pay money, which is sometimes the case, and in fact is very frequently the case when a holding company guarantees the contracts of its subsidiary, it's unusual for the guarantor to step in and perform personally. Rather, they will pay damages in lieu of performance. If the principal debtor performs their contract, their principal obligation, then of course the principal creditor has no recourse against the guarantor. Because the principal debtor has performed, then the guarantor is not in a position where they're required to perform. Their liability is a contingent liability. It's contingent on default by the debtor, and if the debtor doesn't default, then the duty of the guarantor does not vest in interest. You remember when I talked to you about the debts vesting in contingency or vesting in interest, and then you've got your accrued debts and your present debts, the two kinds of debts vested in interest. Exactly the same is true of all law, all obligations, including guarantees. It's a contingent liability. It becomes a liability vested in interest if the debtor defaults, and then it's a question whether or not the obligation of the guarantor is accrued or is present. That will depend on whether the occasion for performance is true now or lies in the future. So all of that analysis of the nature of the duty applies equally to the guarantor as well. A guarantee must be supported by consideration unless the guarantee is by deed. So you could execute a guarantee by deed under the Property Law Act. Then consideration is not relevant. But the general rules of contractual formation apply to guarantees. Hence, they've got to be supported by consideration. Well, you might say, well, yeah, but so what? Well, the so what is that actually sometimes it can be a bit hard to understand what is the consideration provided for the guarantee. And the reason why this is so is because sometimes you find that the guarantee is entered into after the formation of the primary contract between the principal creditor and the principal debtor. And so if that's already in existence, what's the consideration that's provided to support the guarantee? And, you know, a pre-existing debt is not good consideration. That's just standard law. So if you've already got a principal debtor-creditor relationship, then the pre-existing debt is not good consideration for a guarantee by a third party. However, forbearance to sue, a promise not to sue to enforce the existing debt, may be good consideration for the guarantee, and may be implicit from the nature of the transaction. So it may be implicit that the principal creditor is saying, I promise not to sue the debtor if you agree to guarantee the debt. And if the person guarantees the debt, then there is good consideration for the guarantee. Okay, so it is possible to see forbearance to sue as being implicit from the nature of the transaction. And here's an example, and this, it's very simple. I've done it in very, very simple terms, very short set of facts, but it's actually based on very long-standing law. So A is a debtor of B, so there's a pre-existing debt between A and B. B is the creditor, A is the debtor. At B's request, so the creditor requests C. C says to B, I personally guarantee A's debt. A does not pay B, so the debtor defaults and becomes insolvent. The issue is whether the creditor can recover from C or not. So this is, you know, what's the consideration for this this promise by C, the promise by C to B, I personally guarantee A's debt. That's a contractual promise. What's the consideration for the promise? The consideration is an implicit forbearance to sue. Why is there an implicit forbearance to sue? Because of the fact that the creditor has requested the guarantee. It's implicit. The law says this. The case law says this, and it has done for about 200 years, that a request by the creditor for a guarantee, it's implicit that without it they will sue to enforce the debt. So there's an implicit forbearance to sue, an implicit promise not to enforce the debt is the consideration provided to support the promise to guarantee. Okay, so B can recover from C. There is a valid guarantee here, subject to what I have to say later about formalities. But so yeah, that's testing the second proposition here. Requests are thought to imply forbearance to sue in consideration of a contractual promise to guarantee. Formalities. A guarantee is not enforceable by civil proceedings unless it is in writing and signed by the guarantor. This is in the Property Law Act. You don't need to know what section it's there. It's been in the Statute of Frauds in the 17th century Contracts Enforcement Act. It's now in the Property Law Act. But it's interesting that it's not necessary for the consideration for the guarantee to be in writing. Okay, so it's only the guarantee itself, the undertaking by the guarantor, the surety in favour of the principal creditor. So, So in this case here, if this were purely verbal, it wouldn't be enforceable unless that's in writing. okay, because of this rule here in the Property Law Act. Guarantees must be in writing, and of course banks have well-drafted written guarantees in their stock of contracts. A guarantee is not a contract of utmost good faith, and there's no general duty on a bank to disclose information to a potential guarantor. So here the bank is the principal creditor. It's not under a general duty to disclose information to a potential guarantor. Well, you might say, okay, well, what's a contract of utmost good faith? A contract of utmost good faith is contract of insurance. Why is it a contract of utmost good faith? Because insurance contract indemnify against risk. That's what they do. They indemnify against risk. And it might be the risk of professional liability. It might be the risk of an earthquake. It's a contract indemnifying, promising to pay somebody a sum of money to compensate them for the loss that they suffer from the realization of some risk. Okay, now because it's a contract to indemnify risk, the insurer needs to know what risks there are, because they've got to set their premium to reflect the risks or to offset by reinsuring. And what insurance is a pooling of funds to amongst all the insurance holders, policy holders. So they're sharing risk across the whole community of the insured, which is why insurance contracts don't and shouldn't apply to pre-existing conditions. There's no risk there if there's a pre-existing condition. There's no risk. It's certain. That's why the American medical insurance law is now very anomalous. Anyway, why am I going on about this? Well, because with contracts of indemnity, the person seeking indemnity needs to disclose all the risks that they are liable to or susceptible to, so that the person taking on the risk, namely the insurance company, can make a decision whether to indemnify and the premium. So you've got to disclose all material risks. A guarantee is not a contract of that type. It is not an indemnity. And so there's no general duty on the bank to disclose information to a potential guarantor. That's the general rule. Exceptionally, the bank must answer accurately questions directly posed by a potential guarantor. That if they don't, then there's the issue of contractual misrepresentation and the like. And then, although there's the precise scope of the information that may be divulged by the bank is unclear. Why? Well, because of the duty of confidence, which I've already taught you about. Yes, so that places some constraints, and the bank might very well need to get the consent of the principal debtor before it makes disclosure in answer to questions. Okay, the bank has a duty to... I want to make a point here. The bank must answer questions accurately. The issue whether the bank has to answer the questions is a distinct issue, but if it decides to answer the question, it must do so accurately, otherwise we're talking about misrepresentation. Whether there's actually a duty to answer questions is a distinct question. So a bank could say, no, we're not going to answer that question. Generally speaking, that's consistent with the general rule that the bank has no general duty to disclose information. But if it chooses to answer the question, then it must do so accurately. Why? Because of the provisions on misrepresentation in the Contracts and Commercial Law Act of 2017, I think. But there is a narrower duty in these circumstances. So the bank does have a positive duty to a potential guarantor to disclose relevant information if there's anything in the transaction between the bank and its customer that makes the position of the customer different from that which a surety would naturally expect. If there's something unusual about this, the transaction to be guaranteed. Or secondly, if the potential guarantor suffers from a disadvantage known to the bank, a disadvantage in the sense of the equitable doctrine of undue influence, which I'll get to presently. Now, I think I might stop at that point. I think I've been going for 50 minutes or possibly more. So let's just stop at that point. So that's slide 9. I will stop there. Yeah, okay. So, and I hope to see you all tomorrow at the lecture and also the tutorials tomorrow and Thursday to look at the Reserve Bank's proposed abolition of money. Thank you.